the Roberts Court's apparent interest in business law cases. It's been observed by many that it appears to be taking more of these cases, more cases that matter to the business community and that relate to business law issues. And the suggestion that the Roberts Court has been not merely interested in these questions, but also perhaps has had a particular interest in how to resolve these questions. And the claim has been made that the Roberts Court is particularly pro-business or sympathetic to business. And the idea was that on the one hand, it's good to have more attention to the handling of these sorts of cases at the Roberts Court. Although I teach constitutional law, I sometimes think that too much of our discussion about the Supreme Court and what the Supreme Court does focuses on the First Amendment or race or sex or things that grab headlines, but actually may not reach as far in terms of the day-to-day practice of law in terms of what the Supreme Court does. So it's good that these sorts of issues are getting more attention, but we also thought that it was worth looking at in more detail and in greater depth what the court is doing and trying to figure out if we can understand, is the court pro-business? Is it sometimes pro-business? If it is, how is it pro-business? What does that mean? And so we invited the four folks we have with us today and tomorrow to present papers on various aspects of this. And I should say this is not the only project of this sort. The Santa Clara Law Review did a couple of years ago, a symposium that I think Brad helped organize, that also looked at some of these questions. But I think these are important questions and that they're worth exploring and toying with. And so hence this colloquium. But you didn't come here to hear me, so let me introduce our first speaker. Adam Pritchard is the Francis and George Skestos Professor of Law at the University of Michigan, where he focuses on securities law, among other things. Even though we're in Cleveland, we shouldn't hold it against him, or perhaps we should hold it in his favor that although he's at Michigan, apparently those that endowed his chair are Buckeye fans. Which may matter for some of the folks here. But anyway, without any further ado, I'm going to turn it over to Adam. He's going to, the format's going to be the same in all of our sessions. The paper author will talk for about 15 minutes, giving us some highlights of the paper, and then after that we will proceed to a moderated discussion, which will basically mean I'll just try and keep you all from talking over one another. But the aim is to have about an hour's worth of discussion on each paper, the issues it raises, things we like in the paper, things we don't like in the paper, other questions that the papers raise. So without any further ado, Adam, the floor is yours.
Thank you, Jonathan, and thank you for the invitation to come speak here. It's an interesting topic. This is my second trip in the span of a week into enemy territory. I took my son to South Bend this weekend, and I returned north of the border after a triumphant victory. So I'm on a roll, and I'm expecting to go home, tomorrow after a triumphant victory. I'm not sure exactly what form that takes at a symposium, but I'm 2-0 so far this year, and trying to make this number 3. So I am primarily an empirical researcher, but I do dabble on the side in Supreme Court history in the field of securities law. So I like to tell my children that I'm the leading historian of securities law in the Supreme Court. I'm also the last in that rank, probably, as well. It's a fairly narrow niche, but somebody has to do it. So I'm pretty much incapable of doing a paper.
Yeah, the button on the bottom should be. One underneath.
Oh, the red one? Oh, understood. All right.
That was designed by someone who does video games or something.
Okay. So I can't do a paper without including a little bit of data. So here's your dollop of data to get you started. So since the securities laws were passed originally, federal securities laws were passed in 1933 to 1935. Supreme Court has heard 116 cases, 1.8 per term. Roberts Court, 9 cases over 5 terms, 1.8 per term. So from that perspective, the long-run perspective, it looks like that this is consistent with long-term averages. I think that overall number, however, is a little bit deceiving there's a big flood of cases immediately after the enactment of the laws, trying to figure out what they mean, and a long, protracted battle over the constitutionality and interpretation of the Public Utilities Holding Company Act, which, well loved by me, but probably most of you are not terribly familiar with PUCA, but it was one of the primary battlegrounds of the fight over the New Deal in the courts. Just to fill you in, the New Deal won. So, but after that, the number of securities cases that the Supreme Court agreed to hear dropped precipitously. So the Warren Court averaged about one case per term. The Berger Court, here's the real uptick, right? Is the Berger Court hearing 3 cases per term over its era. The Rehnquist Court is a reversion to the norm, I guess it's the norm, post-war norm set by the Warren Court of 1 securities case per term. So the outlier here is the Berger Court. What's going on there? And the answer is Lewis Powell is going on there. The uptick is, I am persuaded, all attributable to Lewis Powell, who was a corporate lawyer, which makes him stand out among Supreme Court justices. Before he came to the Supreme Court, he was a corporate lawyer, did securities filings from the 1930s on, and was very interested in the securities laws. So here's a chart of the cases from Powell's time on the court. And there were 41 cases during his time on the court. In 40 of those, Lewis Powell voted to grant cert. Lewis Powell was certain that the Supreme Court needed to hear more securities cases, and he's a pretty reliable vote to grant. The other number from this chart that I think is notable is that he's in the majority on 40 of them. One guy, he knows the field, he cares about it a lot. Everybody else doesn't care at all. He has a lot of sway, right? So he gets the cases granted, and 98% of them come out the way that he wants. And notice this is not just an expertise effect. Down here at the bottom, William O. Douglas, he's probably forgotten most of what he knew about the securities laws by this time, but he did have experience. He was the chairman of the SEC, but you see, he only votes to grant cert in 5 of the 11 cases heard during the time that Powell is on the court while Douglas is on the court. Not that interested in the topic. And he's showing up in dissent most of the time, right? 80% of the time, Douglas is in dissent. So he clearly is not exercising a lot of influence over the court. So is there a new Powell? Do we have someone taking Powell's place on the court in the sense of pushing for securities law cases and exercising a lot of influence? And I think the answer is no. So you look at who has written the majority opinion in these cases, and pretty much it's all over the lot. Breyer has done 2 of them, but that's the 2 cases don't have anything to do with each other. It's not like he's setting some sort of agenda. The person who writes most frequently in the area is Stevens, and mainly to complain that the court is going the wrong way, right? So Stevens appears to care enough to write, but he's not influencing the court. He's mainly writing either in dissent or he's writing a concurrence, which might as well be a dissent because he's complaining about the approach the court is taking to the securities laws. So the numbers are up, but we don't see anyone taking this field as their own in the way that Powell did. So that's all your data. That's all I got. So, but I will continue to talk because we are here. So what do they care about? So this is more doctrinal, impressionistic from reading the cases. I've sorted the cases into 3 categories of topics that seem to interest the justices in the opinions. And when I say interest the justices, insofar as there's a dissent or a concurrence, this is the issue that they are fighting over in the opinions. So, statutory interpretation, and I just want to pick a couple illustrative examples. The Securities Litigation Uniform Standards Act. I actually, when I was at the SEC, played a role in the drafting of SLUSA. I am very familiar with its legislative history, and I always tell my students when we get to this part of the class that I helped write that. And I gotta say, it's a boring statute. It is not interesting at all. So, the students are not all that impressed. Oh yeah, you wrote a boring statute, as statutes go. But the basic idea of SLUSA is to preempt state securities class actions in an effort to preserve the federal restrictions on securities class actions. Funnel the cases into federal court where we can apply the tough pleading standards from the Private Securities Litigation Reform Act. And the language that some knucklehead who wrote the Securities Litigation Uniform Standards Act used to convey what was to be preempted is this language that's drawn from Section 10B of the Exchange Act in connection with the purchase or sale of securities. So the question is, does this preempt state securities class actions where there hasn't been a purchase or sale, right? So a friend of mine called me from the SEC's appellate section and said, well, this case is going to the Supreme Court, Adam. You helped work on SLUSA. What do you think? Well, obviously it doesn't preempt that. It requires a purchase or sale. No one ever thought at the time this was being written that there would be a securities class action without a purchase or sale. What court would be wacky enough to do that? So there was no reason to preempt those suits. But of course, there is someone out there wacky enough to do that. And the question is it preempted? So the opinion for the court, there are 2 potential interpretations of this language in connection with the purchase or sale of securities. The court has one interpretation that it adopted in connection with private rights of action under Rule 10b-5, and another interpretation that it adopted in government enforcement actions, so criminal actions by the Justice Department and enforcement actions brought by the SEC. And the opinion for the court says we presume that Congress is aware of this interpretation, and that's what it's meant when it enacted SLUSA. Well, which interpretation, right? It's the one that gives the broader preemption, the one that applies to government enforcement actions. Why is it that interpretation that Congress is presumed to be aware of? Well, that's not entirely clear, because we have 2 interpretations. You have to choose one. Court chooses one, and it says, well, this is what Congress was aware of. I don't know why Congress wasn't aware of the other interpretation, but apparently this is the one they were familiar with. However, the statute says this is supposed to curtail the migration of actions to state court. So the purpose is on the face of the statute. And they choose the interpretation that's consistent with the purpose. If anyone had asked the Congress members, well, should we have non-purchase or sale actions in state court, everyone who voted for this bill would have said no. They didn't include it in the statute, but here we have a statute that includes a purpose provision, so we don't get into one of these disputes between Scalia and some of the liberal members of the court about whether we should construe purpose. Apparently it's okay to look at legislative intent if they put it in the text of the statute, which they did here. So, the other case that's primarily a question of statutory interpretation involves the statute of limitations for Rule 10b-5 causes of action. The language is 2 years after the discovery of the facts constituting the violation. The majority opinion by Breyer says courts consistently interpret discovery to mean discovery or should have been discovered in the exercise of reasonable diligence, and therefore we're going to interpret this the same way. So we're going to interpret it consistent with judicial precedent because, of course, Congress is aware of these prior interpretations of precedent. Scalia dissents. He says you should construe it consistently with the Securities Act. There's a provision like this in the Securities Act, except it says discovery or should have been discovered, right? It has explicitly a constructive discovery provision in it. So Scalia has, language should have consequences, of kind of formalistic approach to the question. He doesn't get many votes for this. No one addresses the fact that Scalia's interpretation would essentially read the statute of limitations out of the statute, right? Because he says the plaintiff has to actually know of the facts constituting the violation. And any halfway decent plaintiff's lawyer can find a plaintiff who knows nothing. There are thousands of plaintiffs to choose from. If one happens to know of the facts constituting the violation, I just go to the next plaintiff until I have a lead plaintiff to bring my case. It is a ridiculous interpretation of the statute, although, it has this nice air of formalism. But Breyer doesn't call him on this, right? That's not part of the discussion. It's all about what we should presume. Should we presume awareness of the interpretations, or should we presume we want the statute to be consistent with other securities laws? All right. Next category I've called the administrative state category. These cases have nothing to do with securities laws, pretty much. They are all about the relationship of the judiciary to the administrative state. The antitrust case is, it's really an antitrust claim, and the question is whether it's preempted by the securities law. And they're fighting the decision of the Warren Court in Silver versus New York Stock Exchange, where Justice Goldberg said, yes, there's the possibility that the securities laws and the antitrust laws could interfere with each other, that they could conflict, but the proper interpretive approach is to construe any implied preemption of the antitrust laws as narrowly as possible. So in Silver, this led to a conclusion that the antitrust laws were violated because due process was violated, which has got to be one of the all-time stupidest antitrust decisions ever. Maybe Tom can speak to this question. Is it one of the stupidest antitrust decisions ever?
Yes.
Yes, that's the right answer. Does anyone think it's a good decision? I don't know. No. So basically, Breyer doesn't overrule Silver, but there's nothing left of it, right? We're going to presume interference with the securities laws. Even when the conduct at question violates the securities laws, we're still going to say that it's preempted. The other decision was, one of these epic, important separation of powers decisions in the Peekaboo case, the Public Accounting Board case. And you can see how important it is because Chief Justice Roberts writes the opinion, and it goes on for many, many, many pages. And it grapples with all of the for-cause removal cases of the Supreme Court. And basically, it's an extended argument that Humphrey's executor was wrongly decided, except we're not going to overrule it. And indeed, we are going to construe the Exchange Act as creating a for-cause provision for removal of SEC commissioners, which creates the constitutional law question to be decided here, right? So we're going to completely ignore the doctrine that you should avoid constitutional questions by construing statutes to avoid them. Here, you wouldn't have to construe it to avoid them. The face of the statute says nothing about for cause. but they end up saying, yes, this is unconstitutional, and the consequence of it is extremely trivial. So now the SEC has the power to remove accounting regulators. There's nothing in the opinion about how this affects accounting regulation. Presumably they don't have much to say about that as the justices. All right. So my last category is the question, which I think is closest to what Jonathan was talking about, whether this is a pro-business court or not. Are the members of the Roberts Court hostile to securities class actions? And the bias, if there is one, that I see in these cases is a bias toward the status quo. So by my tally, we have 2 plaintiff wins in this area, and we have 2 defendant wins. The Tell Labs case is formally a plaintiff loss because it reversed a Seventh Circuit victory for the plaintiffs. But the interpretation that the Seventh Circuit offered of the Private Securities Litigation Reform Act, I can't put it anyway. It was just plain dumb. I can't phrase it any other way. It was dumb. It was undefensible. So the choice was between 2 standards for assessing the inferences in a securities fraud complaint, and did the tie go to the plaintiff or did the tie go to the defendant? The Supreme Court decided that the tie goes to the plaintiff in assessing the inferences of fraud, which really was about the best result the plaintiffs could have hoped for, and it actually reduced the standard in the Ninth Circuit, which is the most important circuit for securities class actions. So Tell Labs is basically the reversal of an outlier Seventh Circuit decision. And so is Jones. Jones is an outlier in the other way. Judge Easterbrook essentially trying to put an end to mutual fund compensation litigation because he thinks judicial review of mutual fund compensation decisions is stupid because there's a very competitive market and people go to the funds that have the lowest costs. The Supreme Court says no. Congress used the magic words fiduciary duty. Fiduciary duty means what we said in Pepper versus Lytton. No reason offered for this at all other than, well, it's a Supreme Court decision, and therefore that must be what Congress meant, was Pepper versus Lytton. But the tenor of it is quite restrained. There's a lot of talk about deference. It reads like a business judgment sort of decision. There will be review, but plaintiffs you should expect to lose. But strictly speaking, the plaintiffs were losing all of these cases before the Seventh Circuit decision. The Supreme Court restores the standard under which they were losing, but rejects the standard that pretty much precluded the litigation in its entirety. The defendant wins are Stone Ridge and National Australia. And of the 9 cases, these 2 are the closest to actual engagement with the securities laws by the Supreme Court. These opinions by Justice Kennedy and Justice Scalia are clearly animated. These are written by the justices, not the law clerks, it seems to me, unlike most of these. Why are the justices all caught up with this? Stone Ridge is, or could be characterized as an attempt by the plaintiff's bar to do an end run around the Supreme Court's rejection of aiding and abetting liability in the central bank case back in 1994. Why is Justice Kennedy worked up? Because he wrote Central Bank. There is precedent, and then there is Kennedy precedent, and we will not have Kennedy precedent undermined. So that pretty much is the explanation of that. National Australia is a Scalia classic, just trashing of the Second Circuit standard for when foreign companies can be sued in the U.S. In a securities class action. And we have this long tirade against the Second Circuit's case law, the conduct and effects tests that the Second Circuit had developed for deciding this question, and a bright line formulation by Justice Scalia of what the correct test should be. But it's clearly Justice Scalia protecting the presumption against the extraterritorial application of U.S. law. It has nothing to do specifically with the securities laws. It is this presumption that Justice Scalia wants lower courts to respect with every federal statute, right? Unless Congress says explicitly this will govern conduct abroad, it is not to be construed in that way. So the conclusion. They are not interested in securities law, right? In some sense, they think it is important, right? There's a lot of money at stake. It has important consequences, but they don't love the securities laws the way I do, or more relevantly, the way Justice Powell did, right? Justice Powell was actively interested, and you look at his correspondence with his clerks and with the other justices, and he's really putting a lot of effort into it. They are not interested in the securities law. There are other debates going on, most prominently debate over statutory interpretation, with both sides saying, my approach to statutory interpretation is going to give a clear roadmap for Congress that will lead to predictable results. Unfortunately, they can't agree on the proper approach, which kind of undermines the predictability point, right? Because it would be predictable if they all did Scalia's routine. It would be predictable if they would all do Breyer's routine. But the justices cannot agree on what is the correct method of statutory interpretation. So I don't have much to say about that debate, but it seems quite inconclusive. One implication of their disinterest that we see is they're going to defer to the government position unless there is some blatant provocation. So the National Australia case with the extraterritoriality, there's no deference to the SEC's position because it flies in the face of this presumption against extraterritorial application that Scalia apparently feels very deeply about. Who knew? He cares a lot about it. Stone Ridge, Justice Kennedy cares a lot about his prior opinion in Central Bank. In those cases, there's going to be less likelihood for deference. There are a couple quotes in the conclusion from the opinion that suggest if there are going to be changes here, it's going to come from Congress, right? We feel that we have a fairly stable set of rules governing these. Congress wants to change the status quo. We'll be happy to do that. The bias is going to be, particularly in the private cause of action cases, we're not going to scale it back, but we're also going to resist efforts to expand the reach of private class actions by roping in third-party defendants in the Stone Ridge case, or by roping in foreign defendants in the National Australia case. That was more than 15 minutes, wasn't it?
That's okay.
All right.
Alrighty. Thank you, Adam. Now we're going to proceed to discussion. I'm going to keep a queue for folks that want in, either with a question or a comment. So just raise your hand or get my attention if you want on that queue. If someone makes a point that you think demands some sort of immediate yet exceedingly brief and pointed intervention, do something like this, and I will try and recognize you for that. That is a way to jump the queue. Note, however, though, if that privilege is abused, I probably won't notice you the next time you seek to jump the queue in that fashion. Adam, as our paper author, will kind of retain an ability to intervene when he feels necessary to preserve his winning record.
And I'll still get called on, even
And
if I do.
It's your paper, so you'll get in. But I saw some hands starting over here, and Justice Strauss.
All right. So one question I have, I'm interested in why the court's taking these cases. It seems like this is almost a statistical anomaly in the sense that they're taking, as you argue, they're taking these cases with other drivers in mind, like statutory interpretation and other such things. So the question then becomes, is this going to be a statistical anomaly? Are we going to see the court revert to taking one case a year because they're really not that interested in securities law? I guess the question is, can you venture a guess as to where we're going over
What's
the next
my
5 years?
long-term projection?
Yeah.
So my projection for next year is 2. Oh, they've already granted those. So they won't grant another one, is my guess. There are circuit splits generating most of these. Clear circuit splits that are not going to resolve themselves. A lot of them arise out of either the Private Securities Litigation Reform Act, which was passed in 1995, so it's still percolating issues up, or the Securities Litigation Uniform Standards Act, which was passed in 1998. So 2 relatively recent statutes that, at least in the case of the PSLRA, Congress left a lot for judicial interpretation because that was what was needed to get the law passed over President Clinton's veto. So it generates a lot of splits. So they feel an obligation to resolve splits. There are lots of splits out there, right? So why pick these? I do think that there are at least 4 justices who think this is an important area of the law, right? Because there's a lot of money involved, and part of what we should do here is have predictable rules in this area that has a lot of economic consequences. They're not particularly interested in it, but they feel a certain obligation. That's why I think they're taking the cases. Almost all of them involve circuit splits. It's not like in Powell's day where he would reach out to overrule a Second Circuit decision that he thought was dangerous. So there is going to be a circuit split. I mean, a couple of these are deliberate provocations by lower courts. The Seventh Circuit decisions are deliberate provocations. That are either going against the grain of all the other decisions in the area, creating a circuit split that's hard to ignore. So once the PSLRA and SLUSA get settled down a bit, I would predict a reversion back toward 1 case per term.
Jay?
Yeah, I disagree with that. For me, I watch these cases too as a securities professor and lawyer, and I see the court aggressively trying to rewrite the rules in class actions. You know, you mentioned that there are circuit splits, and I agree that, of course, it's almost always the case there's a circuit split before a court will take a case, but that doesn't necessarily tell you what circuit split they're going to take, because there are plenty of them out there. I'd say the Seventh Circuit case in Tellabs was not sure the the Seventh Circuit was out on its own, but that was the first time a decision went that far, and the court immediately took it up, right? So they didn't sort of let it percolate, let other courts weigh in on the Seventh Circuit. I would say that with Stone Ridge.
Well, there were 7 or 8 interpretations on that question prior to Tellabs. So
Right, but there was none as extreme as the Seventh Circuit, and that was
Right.
the case that seemed to attract their attention. I would say that Stone Ridge, there were only 3 cases, right, that had dealt with that issue, 2 of them arising out of Enron, or 1 of them arising out of Enron. And the court seemed to take it up really quickly. You know, before again, and you had the 1 Ninth Circuit test where they found there could be liability, before there was really much of a chance of the circuits really too much to develop it. You know, the language in Stone Ridge where Kennedy says, I'm drawing a line in the sand, no more extension of 10b-5. You know, you have some pretty provocative comments out there that seem like, and that's, you know, that's a novel doctrine, right, in the 10b-5 area. We've never had a majority of the court say, our principal line of reasoning won't be the common law, it won't be congressional intent, it won't be anything other than, because we don't like private right of actions, we're going to draw a line in the sand. So, you know, I agree that, you know, the cases you put up are right in terms of plaintiff and defendant, including you could put Merck up, I think, as a plaintiff win. So I do think the court doesn't have 5 votes that are always consistently, you know, we're going to run securities class actions into the ground. But I think there's a core that want to do that. And so it sort of, you know, sometimes they can get all 5 in Stone Ridge, and sometimes they can't.
I wouldn't infer too much from Stone Ridge, because I think it's traceable to Kennedy's involvement with central bank, right? That it's clearly, from his perspective, an attempt by the plaintiff's bar to do an end run around what he thought were the restrictions he imposed in central bank, which was a little odd because he originally voted the other way in central bank. He was assigned to write the opinion saying that there was a cause of action for aiding and abetting, and he came back with an opinion saying there wasn't, right? Much to Justice Blackmun's dismay, presumably, who assigned the opinion to him. So, but you know, he's a convert, right? So he believes fervently in this restriction. I mean, the other cases, I mean, if there was a serious coalition trying to cut back on securities class action, Tell Labs would have come out the other way, right? It would have come out that ties go to the defendant rather than ties go to the plaintiff. Because I don't see anything in the text or the legislative history that tells you the answer to that, right? The arguments on both sides, equal versus preponderance, that depends on your predilection, right? And there are two justices who have the predilection, Scalia and Alito, that it should be a preponderance, that's what should be required, but the majority pick the intermediate position, right? So we have an extreme position on the Ninth Circuit side, we have an extreme position on the Seventh Circuit side, so we'll take the one in the middle, which it just so happens turns out to be more favorable to plaintiffs than to defendants because of who had staked out the position on the more stringent side, which was the Ninth Circuit. It's the more important securities venue than the others.
David?
Yeah. So these are sort of orthogonal questions, but I had a couple related to sort of a broader sweep of history than the particular cases decided by the Roberts Court. And the first is a surmise that, and you suggested that this might be the case with Puka and the passage of the 33 and 34 Act, that the Supreme Court's more likely to take a case involving a statute when it's sort of an issue of first impression shortly after the statute's been passed. And to me, this is really not my area that I'm about to reveal, but to me, one of the surprising things to me, it could be that the surprise here is the Rehnquist Court, right? Because then Congress did get involved in reforming the securities laws. It passed the PSLRA and it passed SLUSA, and the Rehnquist Court didn't hear those cases. So I sort of wonder if that suggests that either the Roberts Court is trying to catch up, or if you think that the interesting story to tell with the Supreme Court disengagement with the securities laws is particularly poignant or whatever for the Rehnquist Court. So that was question number one. Question number two is about the Powell story that you tell, and I buy that he was very interested in securities litigation cases, and here again reveal some ignorance. But my sense is that securities litigation really exploded during the Powell era, not in a way that Powell necessarily would have endorsed. I mean, we see the growth of insider trading and the growth of, and the okaying by the Supreme Court of class actions. And so, I feel like that's what sort of created the securities litigation we have. And I don't know if it's really what Justice Powell would have wanted. So I wonder if, it's possible, in looking at the number of cases in which any one justice was involved or voted yes on even, if it's possible to miss those really seminal cases which announce that you can aggregate lots of small claims, or that insider trading prosecutions are hereby okay or whatever. So, and I wondered if you thought there was anything like that going on in the Roberts Court, maybe, for example, with class actions, where it looks like they really are trying to do some seminal things that may not be apparent by the sort of just looking at the aggregate numbers of securities cases that they take.
So let me go in reverse order, because that might be easier. So when Powell comes to the court in 71, the federal rules of civil procedure were revised in 1967. Rule 23, 67?
6.
66, to make securities class actions possible. The change in 66 is transformative in the field of securities litigation. We did not see securities class actions before that. So that change in the rules is the beginning of a cottage industry in securities class actions. And in conjunction with that, a very aggressive Second Circuit, right? This is the mother circuit of securities laws, and during that time, the Second Circuit is pushing the boundaries further and further. And you're right to invoke insider trading too, because the Second Circuit is also pushing the boundaries of insider trading law, right? This is the SEC's new agenda, and the Second Circuit is on board, and they're clearly pushing it into new areas. And Powell is the brake on that trend. So there are a lot of cases, I think both are true, right? There are a lot of cases because of the 66 change to the Federal Rules of Civil Procedure and what's happening in the Second Circuit, but also because Powell is aggressively reaching out to reject some of what the Second Circuit is doing. And that's most noticeable in the field of insider trading, where there are no splits, right? Those cases are coming up from the Second Circuit without a split because Powell thinks they should be decided because he thinks the Second Circuit is running amok. So is there something driving the bump up in the Roberts Court? And the PSLRA and SLUSA are good examples. The first part of your question is, well, why wasn't the Rehnquist Court resolving some of those issues? And I mean, I do think that is a question of inclination, right? So the splits are being created, but you can always say, well, we should wait a little bit longer until it's more fully developed. And the splits over, the key split in the Private Securities Litigation Act is not over this competing inferences to be drawn. It is over the Sienter standard itself, and that split was evident as of 1998, 1999, and there were a number of petitions, and the Supreme Court denied them, right? So there's a clear split. This new law, it has important implications for securities litigation, and the Rehnquist Court, there were not 4 votes to hear those cases. And now the Roberts Court seems to be more willing to grant them. Maybe they're more interested, maybe the split is more firmly entrenched, so they feel the obligation to resolve it. I can't untangle those two explanations for the why now and not 2003.
Alan?
Am I next up?
Yes.
Oh, okay. So I got a couple of observations and questions. One, on the percentage numbers which you had at the beginning, they weren't in your paper, and I found them very interesting, and I hope you put them in the paper.
Yeah, I did them yesterday, and,
Okay.
and you're right, they should go in the
Okay.
paper now that I've actually done
But
that.
having said that, I have a comment about them, and that is, you've only got the number of grants. You also need to take the denominator, which is the number of cases heard. And in Powell's day, they were
Or
hearing
the number
100
of petitions too.
Well,
Both
maybe
are relevant,
petitions,
yeah.
but petitions are harder because you can't tell which ones are really good petitions. It's much more value judgment.
Yeah.
But the numbers on grants, Powell, until Rehnquist came along, they were hearing 140 to 150 cases a year. They're now hearing 75.
80.
So, in fact, if you do if my math is right,
Percentage of
it's
the docket.
It's 3.5% now it's twice as many, effectively twice as many cases that they're hearing now. It's as though they're hearing 3.5 cases now because as a percentage of the docket. So that seems to me to make the point even stronger for you. The second is, in the Powell era, the court was much more willing to take cases that they thought were important and wrongly decided than the court is now. That is, if you look at what the court both says and does, they're myopic in their focus on splits and determined not to take cases that don't have splits, except when they really, really want them. So that's, in part, that's an understandable why Powell would have been able to exercise the authority to take cases, because other people were using their authority to get other areas of cases granted, and so he wouldn't probably have had that influence today. At least it's at least arguable. Third comment: you have a very brief note to your prior paper on Powell, which I had not read. I would urge you to put a couple of paragraphs in this paper about what Powell's actual role was as a securities lawyer. That is, was he a litigator? Was he a business advisor? Or, he surely didn't have much in the way of class action experience, because, as you just said, there were no class actions until that time. But it would help round out the paper, it seems to me. On the Merck case, part of the reason that Scalia's opinion is so bizarre is that the plaintiff in the Merck case was arguing for the standard that Breyer had. He wasn't arguing for the standard that Scalia put in. Scalia invented this on his own, even though nobody was asking for it. And if he thought maybe that was the right standard, he could have written a concurring opinion which says, well, at least it's that, and we're not deciding whether it's anything else. If we get a case when somebody has that, we'll decide it. But he was bound and determined to do what he's always bound and determined to do, which is to tell you what he thinks the answer is, even if
He's certain of the answer,
He's certain,
even though it's
yeah.
it's clearly wrong.
The last thing about the F-Cube case, as it's commonly known, I mean, Scalia says that this is extraterritorial effect. Well, as your paper points out, the actual fraud was committed in Florida by a wholly owned U.S. subsidiary, and the ultimate violation occurs only when the securities are sold, because it's not a common law fraud case. But in terms of all the reasons why the court has always said we don't give extraterritorial effect because people will engage in primary conduct not knowing what laws are going to apply, we'll have to get witnesses from outside the United States, none of that has anything to do with this. All of that was argued, and Scalia just sort of gave it the back of his hand. And at the very least, it suggests that there is more going on there, that he's really outcome determinative, that he doesn't like these cases in the federal courts, and that if Congress, as he said at one point, if Congress wants to put these cases in the federal courts, it knows how to do it, and it hasn't done it.
It apparently doesn't know how to do it, but
Well,
it should.
yeah. So anyway, I thought it was a very interesting paper, and I agree with your scorecard in terms of winners and losers.
On that last point, I mean, I think the driver is the conflict with the regimes of other countries, right? So I generally think amicus briefs are ignored, but I think the amicus briefs in the National Australia case,
I agree with you.
filed by France and
Australia,
right, saying that this is inappropriate to regulate our companies through U.S. class actions. So I think, I mean, that's included in the opinion, which is not Scalia's style ordinarily, right? It's kind of this policy managing relations with
normally he
foreign
says we don't care about the consequences. I mean, he had an opinion this year in which he said we would be worried about the consequences. Be damned, both sides say the consequences should be A or B. We won't pay any attention to it at all because the statute is so clear.
Right. And here it's going to interfere with the operation of the securities laws in France, and I think that's an important driver of that decision, which I think it should be, right? Australia has securities class actions. They have different rules for them than we do, but it's Australian plaintiffs, Australian company. I don't think it's too much of a stretch to say that those lawsuits should proceed in Australia rather than in the U.S., and that was the overwhelming sentiment of the justices from the tenor of the oral argument. Yep. I think it was Stevens maybe who said this has Australia written all over it. One of the liberal justices, very, very skeptical.
The SEC was, of course, on the side of the plaintiffs, more or less.
Well, they were on the side of the SEC, right?
Yes,
Which
they wanted to be able to do it themselves. They didn't want, and that would have been just as intrusive. Maybe not quite as intrusive.
Not quite as intrusive because there is some prosecutorial discretion by the SEC, and they actually do talk to foreign securities regulators. The plaintiffs' lawyers, some of them talk with foreign plaintiffs' lawyers, but others are in competition with the foreign plaintiffs' lawyers. So there's at least one case, the CP Ships case, where they certified the class and included Canadian investors in the class, even though there was a parallel Canadian class action at the time, which the Canadian courts maybe thought they should be adjudicating. It was against a Canadian company. So there are some very aggressive lower courts in terms of bringing in cases into the U.S. in a way that there's no good way of managing that conflict, right, between adjudications elsewhere if there's going to be this open-ended standard. And Scalia is trying to give narrower rules of the road so that there will be fewer of those situations, I think.
Adam, could you say a little bit more about what role you think the Congress here plays, and not the Congress in particular, but the judiciary's image of the Congress? You mentioned in your talk that both sides say, well, if you follow our rules here, or my jurisprudence, Congress will have something to rely on, except that the justices can't agree on that. Congress? What kind of Congress do they have in mind? Are they living in the same country we're all living in?
This is a Congress that sits around reading the federal reports and the U.S. Supreme Court
and then acts with, as you say in the paper, with minimum rationality, or something like that. That's not an assumption, that's a counterfactual, right? What everyone assumes is there are only two options. Either Congress will do nothing at all, or it will react with 2,400 pages, and once it's passed, we all have the luxury of finding out what's actually in it. And I mean, is that really how they think about Congress? That is, do they have this idealized New Dealish picture of, we say something, Congress deliberates and reacts, and then it's another round in the game? Or is there a chance that at some point they might wake up and figure out that it's just very, very hard to have a dialogue with a completely distracted and over-the-top institution? We see this, in some parts of the sort of corporate bar. I remember this. This is not my field. I don't know anything about it. Moderated this panel, and sort of Harvey Pitt is on the panel. This is before Stonebridge, and he says, expansions like this really shouldn't be decided by the courts. They should be decided by Congress. You really want this question to go to Congress? No. Well, then why do you say that? Right? Because, that's the last thing anybody wants Congress involved with this. And so the logical conclusion, well, if not Congress, well, there's got to be, either the court will sort out the rules, or nobody else, or nobody will at all. Whether all of this is leading is, the question is, even if Congress is a big scarecrow in the back, and so you can't do as a justice anything dramatic about 10b-5 private rights of action because Congress will really bite back. Is there some sense, could it be the case that the justices have noticed that Congress is more or less paralyzed in this field, and so it has to give a little more guidance to people who actually have to live with these rules?
So there are a variety of statements about what Congress is aware of, right, in these opinions. And they're ludicrous on their face, right? No serious person can think that Congress actually operates in this way. And the justices are serious people, right? They know that that is not how Congress operates, that they're not sitting around reading the federal reports. So, but they still use this rhetoric, right? Although Scalia, it's sometimes Congress should act this way, right? And we know they don't, but to hell with them, right? This is how they are supposed to operate in our constitutional scheme, and the fact that they don't is disappointing. But it's not my fault that they can't do their part in the constitutional order. So, what's interesting is that you get results that are consistent with congressional intent, like the Slusa case where in Merrill Lynch versus Dabbitt, where they say it's preempted, right? This is what Congress was trying to do in this area, but the reasons offered for it are, you can't take that seriously, right? There are these two interpretations, and Congress is presumed to be aware of this one and not the other. What? It makes no sense at all. So there's apparently a norm that you have to offer reasons that we are discerning congressional intent that is respected by the justices, even when everyone knows, and they sit in Washington, they know what goes on across the street. They respect that norm even though it's clearly a fiction. Now, you asked about are they going to leave this to Congress? Congress is dysfunctional. Well, my instinct is they don't see that. They're taking a longer term view of this. Congress passed the Private Securities Litigation Reform Act of 1995, which was a major restructuring of the Rule 10b-5 cause of action. From their perspective, this is one very small part of the docket. Lots and lots of other issues that are coming across the transom. And that looks like, well, yeah, Congress passed this law in 95, and then here's another one in 1998. They're pretty engaged with this. So it's not unreasonable to think that Congress will step in again, and as a result, we can be relatively hands-off. So, yeah, I think that part they may, the part about, well, Congress has done this, I think they may actually take that seriously, because this is not like the Sherman Act where, generations will go by before Congress does something again. Congress has been there at least recently, and they're gonna, if Congress wants to do something more, they're happy to see it.
Matt?
I was wondering what you thought about the court's view of its role and the role of securities regulation more generally in two different areas. One is just in terms of the overall regulation of corporate malfeasance and corporate governance more generally. In the 70s, particularly in the Santa Fe decision, you saw the justices kind of carve out a role for state law. And I'm wondering if you see something similar to that here. Obviously, SLUSA kind of goes in a different direction, but the SLUSA is trying to prevent these class action cases, which are not really in the traditional derivatives actions that were being protected in the Santa Fe case. But I'm wondering if the federalism concerns and the idea that we want to carve out a chunk of corporate governance law for the states is there at all in this court's set of decisions. My other question is, in terms of the criminal statutes, whether you see the court looking at this vis-a-vis the concurrent criminal actions that are happening in a lot of these cases, and whether you see any parallels between what the court is doing in things like the Skilling case, honest services cases, and the securities actions cases. In terms of, are they recognizing that this is kind of an overall effort to regulate corporate malfeasance, or are they treating these as very separate things because they're very separate statutory schemes?
So, in terms of the federalism aspect, I don't see any of that, right? I think this is all about interpreting the federal scheme, and my instinct is that ship has sailed, right? That after Sarbanes-Oxley, that Congress clearly doesn't care about preserving the role for states in governance, and none of the justices is engaged enough in this area to think that is important, right? So for Powell, that was important, right? That's one of the drivers of the CTS decision that validated state anti-takeover laws, was that Powell saw it as the traditional province of state law, and he thought that was worth preserving. I don't think that any of the current justices would take that view. So, I mean, that was a flip from an earlier generation, right, where people like Douglas favored federal incorporation, right, that they thought state standards were a race to the bottom. So I don't think there's anyone animated by the federalism concern. The breakdown between private actions and government actions, I think, is important, right? It clearly is driving the Stone Ridge decision. Why is it a reliance element? Because reliance, if we put it on the reliance element, we can curtail the private class actions without restricting the SEC or the Justice Department. And the allegations in Stone Ridge are a bad set of facts, right? That these third-party vendors are engaged in fraudulent transactions in an effort to help the primary defendant fabricate its financial statements. So I don't think there are 5 justices who want to say that that's going to get off scot-free, right? There's got to be someone who can go after that sort of conduct, and the Stone Ridge decision says that's the SEC, and if it's bad enough, the Justice Department can do that. The other, I mean, I don't cover this in this article because I don't know enough about it, but the honest services case, right? There may be something about some deference to state standards there, right? Because the honest services fraud's being used by federal prosecutors to do a federalization of fiduciary duty, right? And they acted to curtail that. So that was quite a significant decision. I'm just not, an expert on that particular area.
Just a comment on that federalism point. I think that one way in which the states, even though they're largely preempted from acting and are trying to act, is through bringing their own suits as institutional litigants on behalf of the pension funds, and then participating in these cases by filing amicus briefs that are very pro-plaintiff because they are the plaintiffs. That's not why I had raised my hand. I just had a very small bore question. I was a little surprised, this isn't my area so I don't pay much attention, to hear you say that the Ninth Circuit is the main venue for, the biggest circuit for class actions, and I take it that's just because plaintiffs' lawyers think it's a good place to be.
No, it's where the defendants are. They think it's a bad place to be.
Well, so then the Second Circuit, I take it, is still also a significant place for securities litigation. Does that make Sotomayor a justice who might actually be more engaged than others, or not necessarily?
She was recused in National Australia because it was coming from the Second Circuit. So I think she's only been in one of these, maybe 2. So she would have sat on the Jones case, which was the mutual fund case, and Merck, which was from the Third Circuit.
You said a peekaboo too.
Right. We strictly speaking are calling that a securities case, but it doesn't have anything to do with the securities law.
Right.
So, I don't know about her track record from the Second Circuit, but yes, it is an important part of the Second Circuit's docket. The gap between the Ninth Circuit and the Second Circuit is not that great. They do have a lot of cases and the longer tradition of being the preeminent securities circuit. So she hasn't written any of the opinions yet, right? And you would have thought a case like Merck, a really boring statute of limitations case, that just has junior justice written all over it, right? But instead it's Breyer. So, I mean, if she wanted it, I'm sure she could have had it. But I think we'll have to wait and see.
Brian?
Just a comment on Ben's point, actually. I have an empirical study coming out later this year, the Journal of Legal Empirical Study, or a Journal of
Empirical legal studies.
Yeah, empirical legal studies, you got it. Looks at all federal court class actions settled over a 2-year period, and 25% of all class actions that are settled in district courts in the Ninth Circuit. And the strangest, this most surprising thing to me, consistent with what Adam just said, is that the attorney's fees awarded by the judges in the Ninth Circuit are actually lower than almost every other circuit when you control for other variables. And it's really surprising, really surprising. That's not why I raised my hand. I raised my hand because there was so much Scalia bashing going on. As a former Scalia clerk, I felt I had to say something. The first thing I want to say is, Adam, I think in your presentation...
I want to point out I am a Scalia clerk in law.
You're a Scalia clerk at...
Clerk in law.
Clerk in law, okay.
Clerk in law. So, I get a lot of abuse at
Well,
home
your
if
spouse,
I'm...
I guess.
Yeah.
She's not doing a good enough job. But so in your presentation, you said that Scalia's view in the Merck case was so crazy it would read the statute of limitations out. But there is the 5-year second part of the statute of limitations that would still apply.
We would just have the statute of repose.
Okay.
Right.
So it wouldn't be like an infinite period to sue. You still have a 5-year backdrop. Secondly, the notion that it is a counterfactual or unrealistic to believe that Congress does any of the things the court assumes it to do. I worked in the U.S. Senate for a year. I second that notion. However, I think the point of the assumption is not to, just doggedly assume something in the face of all contrary evidence. I think the point of the assumption is to give incentives for Congress to do certain things. If you set forth default rules that say, Congress, we assume when you do something, we assume it means X, you create incentives for Congress to do those things if Congress wants their laws to be given the intended effect. So if you don't dot your I's, we're not going to do something. It gives an incentive for Congress to dot their I's. And so I think the point is to give incentives to the legislative branch to do things in a way that makes it clearer for the court to interpret what they want to do. And whether they're successful in doing that, I don't know, but I think there's some reason to it. And the last thing I'll say, and this is off the Scalia point, I just wanted to associate myself with your comments at the outset in response to David's question about why the court is taking these cases. I was so impressed when I was a law clerk with their sense of obligation to take cases with circuit splits. And I saw it most vividly in ERISA cases, which all hated.
Yeah.
But there were three circuit splits, and they said we have to take it. And I agree with you. I think a similar thing is going on in Securities area. And the truth of the matter is, there aren't very many cases where there are real nice circuit splits. They don't come up that often. And when there is a 2-2 circuit split or a 2-1 circuit split that's a real sharp split, the court takes it as a matter of obligation, even if they're bored to death by the circuit matter.
They have to decide some cases. So, and I think it is obligation. They think it's their job, which I think it's their job too. So I don't disagree with that. What you say about the default rules, I endorse as a normative matter wholeheartedly. That makes perfect sense to me. But there ought to be clear rules of interpretation which give a backdrop against which Congress legislates. You do X, you will produce consequence Y. All right? That strikes me as perfectly coherent. Unfortunately, the justices cannot agree on those default rules, right? If they could play nice with each other, I don't really care what the default rules are. They're probably not that important. They fight ad nauseum over what those default rules should be, and apparently there is some coalition in the middle that refuses to sign on to either set of default rules, right? So here are your clear rules for the road. Well, and here's another set of clear rules for the road, Congress, and sometimes we'll pick this set and sometimes we'll pick that set. Both sets of rules may be perfectly coherent, but no one's willing to budge, right? I'm on this side of statutory interpretation, you're on the other side of statutory interpretation, and there are not 5 votes for one method of statutory interpretation. And they're continually cycling over what that ought to be. So they announce these decisions which have a perfectly coherent project of, we're generalist judges, don't expect us to be experts in this area and able to do purposive interpretation because we're simply not competent, right? We're not securities law guys, we're not ERISA guys, we interpret statutes. So if they got a more limited role, which is we're going to interpret statutes, this is all going to make perfect sense if they could agree on the rules, right? So I'm okay with the assumptions about Congress being unrealistic if they could just agree on their assumptions. They can be fictional as long as they are agreed in fictional.
David, you want to quickly on this point?
Oh, not on this point.
Okay.
I just wanted to.
Then, Josh?
I wanted to piggyback on one of the comments earlier, just about framing the initial empirical question. I'm an antitrust guy who does empirical stuff. This is outside of my strike zone. But interest in cases turns out to be, people say, a big explanation of why the Supreme Court takes a ton of antitrust cases right now. And you look at the bios, and you've got, Roberts is taking cases, and Stevens and Breyer have big antitrust interest, and all the D.C. Circuit people have written opinions, and Alito, and so on. So the story sort of makes some sense, and it's fine. The earlier comment about the denominator being important to the story, in the way that I read the paper now, it reads sort of, they're taking so few cases, why, the Powell effect. And so a lot of the paper is about, but why not zero? The tone starts, but why not 0? So we don't have the high number under Powell, we get a drop, but why isn't it 0? Well, they're interested in administrative state or statutory interpretation debates, and so we get 1 a year or something. But if you had the denominator, it might flip the question, which is, why are there so many darn cases in the absence of Powell? And I think it's not just a semantic flip of the research question, because it could be. I mean, you end up going through the same explanatory factors, but the burden then becomes on you to explain, we've got so many but no Powell. Why? Well, has there been a change in the importance of the debates over the administrative state? I'm sure there's a story to be told. Do they care more now about the practical importance of these cases and dollar volume and the like? I think that story would be consistent with what's going on in antitrust, even holding interest levels constant. But it strikes me as you would sort of run through the same explanatory variables and have much of the same paper, but I think it might force you to sort of go through those strands with a little bit more of a sort of comparative approach that would say, I mean, the burden would be on you. What's different now? Now, maybe the numbers don't bear that out when you do the denominator. I don't know, but if they do, right, which I think has been suggested by people who know more about securities laws, that is anything about them than I do. If you have a sort of big number there, then maybe, it might push you to go through some of that explanation, which I think would be interesting to read, and I would like to hear what you have to say about it.
I think the most useful comparator is the Rehnquist court, right? So I don't think the denominator is radically changed from the Rehnquist era, right? The Rehnquist court does 80 cases a year. The Roberts court does 80 cases a year. The Rehnquist court does 1 securities case per year. The Roberts court does 1.8. So it does seem like a jump up from the 1 per year under the Rehnquist court. And I don't think that they're taking these securities cases because of the questions that they debate in the opinions, right? I don't think they take the statute of limitations case to argue over the proper interpretation of discovery in statute of limitations case. I think they took it because there was a split and they felt obliged to do so. Once you've agreed to take the case, what do you talk about? right? What do they debate in the opinions? And it's not securities law topics, right? It is these questions that are pan statute, right? They apply in all federal contexts or the entire federal regulatory state. And because they are generalist judges who have a generalist docket, that's what they lean toward, because they're never going to be capable of deciding securities cases the way I could. And that's sad for them, but you know, I guess they're able to face the day, not being Justice Pritchard. But you can't, they're not, it's just not possible, right? They can't be experts in ERISA, and they can't be experts in tax, and they can't be experts in labor law because of the nature of the job. I think there is something to be said about the confirmation process, maybe, right? That the justices do have a fairly homogeneous background. I don't think someone like Powell would get through the process at this point. They wouldn't be nominated. So I don't know if it's a good thing or a bad thing, right? It may be that the general run of cases comes out better decided if we have generalist judges. It's different. I don't know if it's better or worse. It probably depends on whether you liked Powell's approach to securities law or not. But his strengths there, or at least his experience there, he didn't know what the hell he was doing with con law, right? He had no familiarity with it. He completely felt over his head, confronted with these huge issues over abortion rights and the like. So it was a comfort zone for him.
Jay?
Adam, just a couple of other little things. I mean, you know, I think the difference that you and I have over how to read these cases, some of it comes down to your view of Stone Ridge is simply explained by Kennedy. And I sort of see it as broader than that. One of the things you might want to add in your paper is to add in that, of course, Roberts was recused in that case when it was filed and unrecused. So, I mean, you know, I understand from one action you can't read too much, but it sure looked sort of interesting that when it was clear that 3 of the justices in the majority had been on central banks, you knew how they were going to vote. And other than Roberts, it was going to come down to Alito. Roberts wanted to make, you know, it was possible, could have been 4-4, or could have even been 4-3. So I see.
Didn't Breyer also
Breyer
unrecuse himself?
recused and then did not unrecuse.
He did not unrecuse.
Yes, it was a 5-3 decision. He remained recused. Maybe he didn't want to actually identify the way he wanted to vote, so he remained recused. But
maybe he had greater capital gains implications.
Clearly, Roberts, I think, you know, Roberts did unrecuse. So I, you know, for whatever it's worth. The other thing I would say is, you know, when you keep making the point of this is all about splits in the circuits. What was the split in Merck? It was confused, certainly, right? There was you know, it was bizarre, but as the parties in Merck argued, and as the author of the faculty amicus brief that was cited by Scalia, so I have to confess that, both positively and negatively, I'll confess that also. Yeah, you know, there was confusion in the lower courts, but all of the circuits agreed that there were storm warnings and that
the inquiry notice.
Yeah, exactly. That's right. So I mean, I would characterize that as a need to straighten out the law, perhaps, but I wouldn't characterize it as a circuit split.
I think that I don't have much at stake one way or the other on that, right? Whether it's circuit split or confusion, both seem like legitimate.
But if you're looking at motive of the court, right? In other words, if the main motive is we try to clarify circuit splits, that's really the only reason I'm raising it.
I don't think those motivations are very different, are they? Resolving confusion versus resolving circuit splits. Neither one is we're interested in the securities law. It's a mess, or there are two different kinds of messes in the lower courts, but both are a mess, and the Supreme Court is the one that can resolve it.
I would argue that you're then shifting to say, well, here's another reason that's not a pro-business reason that I will use to justify the court taking the opinion. That would be, you know, in other words, your main argument before was circuit split clarification within the circuits. And we don't see a trend in the securities area. There are other places where it's a mess. We don't see a trend in the securities cases of the court saying, oh, it's a mess. Let me take it and rewrite it. So I'm still just arguing that I think there's more desire to affect securities class actions than I think still your theory or your approach is taking into account.
All right, we disagree.
One just quick thought on that. I mean, I think a lot of certain people have posited that one apparent explanation for the increase in business-related cases generally in the Roberts Court is, some have posited that the court under Roberts is more aggressive at trying to clarify confusion or resolve circuit splits than the Rehnquist Court had. That is to say, the Rehnquist Court was more
Willing to let things
was
percolate
willing to let
longer.
percolate longer, whereas the Roberts Court isn't. And I don't know if the data bears that out, but that's certainly been suggested. The other thing I'm just wondering about is when the court doesn't engage in the policy aspects of securities law, you're taking them at their word in terms of the way they write their opinion that is in fact what's going on, which, I'm not saying that one shouldn't, but that certainly there, a lot of empirical research would say we don't care what, in a lot of cases people would say we don't care what the judges say, let's look at what they do. But could it also be that at least for some of the justices, that they don't want to be Justice Pritchard or Justice Powell. They don't want to be.
They have higher ambitions.
Well, they don't want. Well, they're not higher or lower. They, I mean, in the sense that they self-consciously they are trying to avoid, even if we may not believe they can because of the nature of the case, some of the cases, but trying to avoid deliberately, self-consciously, or even openly engaging in the policy questions and and bending over backwards to, so even in cases
to be above the fray.
Right, so even in cases where the question is so close and the statute is such a mess that some prior has to influence how they come out, that this is a court that bends over backwards to avoid looking like that's what they're doing, because that's not the role that they want themselves to have.
It's not judicial.
Right, it's not judicial, it's not what they want lower courts to do either. Is that a fair, is that?
Well, you see some strong indicia of this, it seems to me. So, Scalia's opinion in Merck, right? That leads to this absurd result if it were to be followed, but it's his chance to show, I do not give a damn about the outcome, right? All I care about is the proper method of statutory interpretation, which I believe is we should interpret the securities laws as a whole. And to show you how strongly committed I am to that, look at this result that I'm willing to do. There's the Thomas concurrence in the Credit Suisse case, where he says there's a savings clause in the Exchange Act, and therefore the antitrust laws are not preempted. It is a very simple method of statutory interpretation. If it were actually implemented in practice, it would be a disaster, right? And Thomas, he doesn't address the fact that it would be a disaster, and I'm quite confident that if we asked him, he'd be, and he was in a talking mood, which he isn't often, he would say, I don't care. If it's a problem, Congress can fix it. And whatever Congress wants to, if Congress wants to amend the statute to apply a different standard, I will be delighted to faithfully apply that. So you see those examples for the true believers, right? Let's call Scalia and Thomas the true believers. The others, however, they seem to be more pragmatic, right? That they are influenced by, presumably, the policy interpretations that they're seeing in the briefs. In most of the cases, they're probably not qualified to assess them, right? It's a very complicated area. The empirical evidence is probably quite messy. They're receiving it through the filters of these self-interested advocates, and they don't want to grapple with it, right? So it's not showing up in the opinions. Are they influenced by it? Sometimes, they can kind of let their guard down, and you see some of it. So Kennedy cites one of the briefs in Stone Ridge about, you know, how this will be disastrous for American competitiveness, which, you know, you're just picking out your friends in the crowd when you're citing that brief. There's no reason to think that's persuasive, and the opposing amicus briefs are not. So, but it's the exception when you see that, right? The Scalia's citation to the foreign governments brief, that strikes me as a little more substantive, like it actually might have influenced the opinion, not just of Scalia, but the others who joined him. That you looked at that and said, well, part of our job is to reconcile American law with the law of foreign countries where there's likely to be a conflict, and the reasons offered by these foreign governments suggest to us that there is a conflict. If Congress wants to create a conflict with France, they can do it, but they'd better be clear that that is what they intend.
Brad?
Oh, I was going to just ask a question, and I think it's kind of pulling back a little bit to the question of whether the Roberts Court is truly pro-business to some degree, and it's a question that relates, I think, to the impression I got from a few of the papers, and that is, and Adam, I drew it in particular from your discussion of Stone Ridge in the paper. To what degree do you think that part of what is going on is a skepticism about private litigation as a means of regulation, and a greater faith in governmental experts in enforcing federal law? And to the extent that that's going on, is there, I guess, some skepticism about public choice theory, about government, that this court isn't so sold on sort of modern economic theories of government, or that it instead is fine with it? Maybe it accepts that, but still it's preferable to private enforcement of these federal regulatory regimes.
I think that the right way of thinking about it is as compared to what? I think there is some element of skepticism toward private rights of action. The language in Stone Ridge is pretty clear to me that the majority of the court believes it was a mistake to create a private right of action under Section 10B, and that the project now is to ameliorate the adverse consequences. However, Congress has effectively validated it by not overturning the judicial creation of Rule 10b-5, right? So Congress stepped into the fray and did not repudiate the Section 10b cause of action, and therefore we're going to have to live with it, but we're not going to expand it. Congress has now entered the fray. We are never going back to the bad old days of judicial invention of these causes of action, and it seems to have, let Pandora out of the box, but it's been validated by Congress. It was Congress's job to repudiate it if it wanted to, and it did not. But you're never going to see another Basic versus Levinson decision, right? That this court is not going to do something like that. And I think there's a majority that sees scheme liability in Stone Ridge, expansion to bring in foreign defendants in national Australia as judicial invention, right? That the Second Circuit is running amok, bringing in the foreign defendants with this conduct and effects test, which is very unpredictable, and we're not going to do things that way, and we don't want you lower courts doing things that way either. But they're not going to take the next step. They're not going to overrule Basic versus Levinson, right? Because Congress could have done that in '95 and it didn't. So it's been validated. They're not going to overrule Basic versus Levinson, although I bet there are 5 justices who think it's a mistake.
we're going to have to end it there. But thank you, Adam, for your paper. And, I forget what the schedule says. I think the schedule says we have 30 minutes, right? Or 15? 15. So quarter after, we will reconvene to turn our attention to antitrust. There's water and coffee in the back. And thanks again.